The title of my presentation this morning is Sharing Lessons, the Challenge of Legal Privilege. It could just as easily have been called Legal Privilege, the Challenge of Sharing Lessons. It depends on your point of view. Either way, it represents a dilemma. Legal privilege is intended to prevent the disclosure of information, and sharing lessons requires a certain amount of disclosure. And I would argue that both these competing aims are important. When legal privilege is mentioned, the criticism I hear is that it hinders the investigation into an accident, it prevents the sharing of the outcome of your investigation, and that because of these two factors, legal privilege prevents improvements in safety being made. I want to challenge that perception. I don't agree that legal privilege prevents the sharing of the information necessary to learn lessons. And rather than hindering an investigation, I would suggest that it can lead to a more productive investigation. So why do we have legal privilege? It's a fundamental legal right. The ability to obtain confidential legal advice and to choose not to disclose information which may prejudice the defence of legal proceedings is intrinsically linked to the right to a fair trial and the right to silence, which is effectively the right not to be compelled to incriminate yourself. The Scottish judge Lord Glennie has said that the maintenance of legal professional privilege is essential to the adversarial process. And litigation is an adversarial process. Both sides are entitled to and will put across their best position. And at the end of the day, there is a winner and a loser. Legal privilege is the right to keep certain communications confidential. There are two types of legal privilege. The first relates to communications between a solicitor and their client, and that covers all methods of communication, whether they're in written form, such as letters or emails, or whether it's a verbal discussion. The second type of privilege extends to documents prepared by a party to a litigation, post litem motam, which just means in contemplation of litigation. The litigation does not have to have begun for the privilege to attach, provided at the time the document is created, there is a reasonable likelihood of litigation. And that could either be a criminal litigation, a prosecution, an inquiry, or a civil claim for damages. The effect of legal privilege is that you cannot be compelled to disclose the content of any privileged document or discussion. That right not to disclose extends to criminal investigations and prosecutions, freedom of information requests, and court orders for the production of documents in any other form of legal proceedings. In relation to health and safety, in Section 20 of the Health and Safety at Work Act, which is the section containing the power for health and safety inspectors to recover evidence in an investigation, it's clearly stated that nothing in this section shall be taken to compel the production by any person of a document of which he would, on the grounds of legal professional privilege, be entitled to withhold. So it's recognised in the Act. In relation to incident investigations, the HSE's Enforcement Guide for Inspectors explains that the rationale for this rule on legal privilege is that every party should be entitled to pursue investigations into the causes of accidents and incidents free from the risk of disclosure. And the guide goes on to advise inspectors, you should not therefore routinely request investigation reports where prosecution is possible. And note that it says possible, not just probable. But legal privilege can be lost. The HSE Enforcement Guide also tells inspectors that privilege belongs to the client, which it does, and not the solicitor. And the client is entitled to waive privilege and disclose the document. And where this is done, the document can be disclosed in evidence. And that's the difficulty. Even if you regard the document as confidential, once a document such as an investigation report has been voluntarily disclosed, either directly to the authorities or to any interested parties, it's no longer protected by legal privilege and it can be produced in evidence against you in legal proceedings. and it can be used in any legal proceedings. Fines for health and safety breaches are now at record levels. In corporate homicide prosecutions, fines will have a significant impact on an organisation's profits. The sentencing guidelines for judges state that fines for corporate homicide should generally be measured in millions. In the case of Cotswold Geotechnical Holdings, which is the only conviction to date for corporate homicide, corporate manslaughter, the judge said it may well be that the fine, in terms of its payment, will put this company into liquidation. If that's the case, it's unfortunate but unavoidable. It's a consequence of the serious breach. And individuals are also at risk of prosecution for safety breaches. Last year, 43 directors and managers were prosecuted for breaches of the Health and Safety at Work Act. And in case you need reminding, imprisonment is now an option for a breach by an individual. In relation to corporate homicide, two of the main elements of that offence are senior management failure and gross negligence. A conclusion in an investigation report which could suggest that the attitude of the company's management has in some way led or encouraged tolerance of poor safety practices could be very prejudicial if put before a jury, even if there is other evidence that that's not an accurate conclusion. And so it's not difficult to see that there needs to be some care taken in relation to investigation reports which are likely to be disclosed or shared with the wider industry. Where a report is going to be made public, there may be a reluctance to highlight certain failings. That may be a conscious decision, or it may be the result of a natural subconscious reluctance to publicly attribute blame. When the Health and Safety Executive commissioned some research into accident investigations, the drivers, the methods, and the outcomes some years ago, their report identified that even then there was an increasingly litigious business climate, and that in this climate it's possible to argue that there is a powerful disincentive to both identifying and subsequently documenting management and organisational factors that may have contributed to an accident. So if something is hindering an investigation, it may not be legal privilege, but rather the fear of having to disclose what you might uncover. There is no doubt that carrying out a detailed and thorough investigation into the cause of an accident is essential to learning from the mistakes and improving safety. The HSE Guidance document on accident and incident investigations tells us that learning the lessons from what you uncover is at the heart of preventing accidents, and carrying out your own health and safety investigations will provide you with a deeper understanding of the risks associated with your work activities. It's difficult to argue with that. Regulation 5 of the Management of Health and Safety at Work regulations imposes a duty on all employers to make arrangements for the effective planning, organisation, control, monitoring and review of the preventive and protective measures to be put in place in relation to workplace risks. The approved code of practice to the regulations states that monitoring includes adequately investigating the immediate and underlying causes of accidents and incidents to ensure that remedial action is taken, lessons are learned, and longer-term objectives are introduced. So it's a legal requirement that accidents are properly investigated, lessons learned, and remedial actions put in place. Sharing the lessons more widely can benefit the safety performance of the industry as a whole. One of the key recommendations of the Maitland report is that the industry should agree principles to ensure that concerns about proprietary information and legal exposure do not prevent rapid sharing amongst operators of lessons which could help mitigate the risk of a serious incident. Now, in light of what I've just said about the importance of legal privilege and the potential consequences of a criminal prosecution, that seems like quite a challenge. I'm certainly not suggesting there's an easy answer, but I do think that in many circumstances it ought to be possible to share relevant information from an investigation without compromising an organisation's defence in the event of a criminal prosecution. It's become common practice when investigating an accident to produce a single detailed report containing all of the information uncovered during the investigation, including things like root cause analysis and sometimes external technical reports that supplement the investigation. It's no doubt convenient to have everything in one comprehensive document, but that means when it comes to disclosure, it's a question of all or nothing. If you produce separate reports, then you can identify the information required depending on the particular purpose of the report. It's a fairly simple solution. If you wish to prepare a report for sharing lessons with the wider community, that report might contain information about the event itself, the undisputed facts. It might include the direct or immediate causes, which again are unlikely to be contentious. And it might include information about post-incident changes that you intend to make, which may be relevant to the wider industry. I would argue, however, that there would be no significant benefit in a report that was being widely disclosed to contain information about matters which are particular to your organisation or the way its safety management system is or was being implemented at the time. Issues in relation to the management of safety in one organisation are unlikely to be directly relevant to other organisations which will have a different management system and quite possibly a different management approach. These issues can still be addressed, but they can be done in a separate legally privileged report for internal use, prepared with legal advice, and in the knowledge that that report will not be produced in evidence in any criminal prosecution. And in my view, that avoids the disincentive that was identified in the HSE research report. Ultimately, it's a management decision whether or not an investigation report is to be prepared in accordance with legal privilege. You need to decide how you're going to proceed at the outset when you're setting out the terms of reference for your investigation. Will there be just one report, or are there going to be a series of reports? Will there be some aspects of the investigation that will be directed by legal advisors and which will remain legally privileged? Sharing lessons in the current legal climate is a real challenge, but it seems to me that rather than hindering an investigation, legal privilege supports an in-depth investigation because it allows that investigation to be undertaken without the risk of exposure to self-incrimination. You don't have to air all of your dirty laundry in public, and there will be dirty laundry. But where there's a relevant issue for the wider industry, then sharing that part of the information should be possible. What needs to be done is separating out the information which is relevant from that which is particular to your own organisation. And if that can be done, then there's a real opportunity to share lessons. Thank you.